guys, welcome to Maneuver. I'm Advocate Nisha Lotia, and today I'm happy to share with you guys a video about my most favorite topic, that is the law of torts. This mini demo lecture will give you the knowledge about the defenses used when there is a civil wrong like professional negligence, defamation, trespass, nuisance, etc. Let me make you aware that even in the practical world, the defense lawyers are most sought after. But before getting started, I want to make you aware about the package what the Maneuver is offering about the live lectures, the ebooks, the shortcut techniques. As we all know that the exam is time constrained, the doubt lectures which will be extremely helpful for you to clear your doubts personally with the mentors, the recorded video in case if you miss any of the lectures, the topic wise test and the mock test without which you cannot appear the entrance exam, guys. The mock test what we offer are the replicas, are same to same that you will face on your examination day, guys. We have the WhatsApp group to keep you motivated, to keep you in touch with the students who are appearing for the same exams. We have 10,000 plus questions which will really take care of your current affairs and all other sections. And the best part is, guys, that we have mentors who appear exams every year. They know all the changes and they know what is the correct type of questions being asked and the correct way of making them to explain you. Okay, so this is what is about Maneuver. The most USP about the Maneuver is the mentorship, guys. The correct mentorship is the only way where you can achieve your desired targets, guys. So what you're waiting for? Book your seat with us and call us on 8828581454. You can visit us on maneuveredu.com law entrance, and you can just fill up the Google form. Okay, you fill up the Google form and our team will get back to you as soon as possible, and the link for the same has been mentioned even in the description, guys. So without wasting any time, let's get started with the defenses. Okay, the general defenses under the law of torts. What I told you, guys, tort is nothing but a civil wrong. Okay, civil wrong, and this is very much different from your contract act. Okay, this is very much different from what is your under your contract act. When there is no contract but yet there is a civil wrong, then you can take the help of the law of torts. Very important is law of torts in your practical life, guys. The first defense is about the consent. Okay, consent means you permit to. When you permit for certain action, then later you cannot claim the damages for the same. When plaintiff himself being the wrongdoer, when you are filing a suit in the court of law, and when you yourself will be a wrongdoer, okay, then it is the act of God. When there are some calamities and there is some problem, then that can be a very good defense, guys. Inevitable accident which you cannot foresee. The necessity, if a larger harm is if a smaller harm is done to avoid the larger harm, then necessity is a very good defense. And last but not the least is your private defense. We all know about this, guys. Before starting with the defense, I would like to make a point over here very clear. A person who is suffering, who is filing a suit, correct, the sufferer who will be filing a suit will be called as a plaintiff, correct, and he is filing a suit against the defendant, correct, defendant. If you own a property or आपकी property में आ जाता है, then you want to file a case for trespass, so you here will be the plaintiff and the opposite party will be the defendant. So who uses this defenses, guys? The defendant uses this defenses. Okay, so this picture has to be clear in your mind before you start for it. Now plaintiff ने तो suit file कर दिया है, but what are the ways? What are the ways then a defendant can prove his point कि what I have done, but there was some reason or there was something which made me do that. Okay, so that can be a very good defense, guys. Am I clear about it? So on this note, let's get started with the first point, that is the consent. Consent is something when you permit to, correct. Now the Latin maxim which is very important as per your entrance exam, ये टॉपिक में से डिफेंसेस में से आप एटलीस्ट 2 to 3 क्वेश्चंस एक्सपेक्ट कर पाओगे. ओके, voluntary non-fit injuria, an injury is not done to one consenting to it. Okay, now over here I've taken a very beautiful case law, that is Hall versus Brooklands Auto Racing Club. Okay, this is very famous in the lawyers lobby, guys. Now what is the case over here? There was a car racing, okay, and these were the stands. correct? Now this is the car, say, of Hall, okay, and this is the car of Brooklyn's, okay. Now they were having this racing, okay, so they were, you know, heading towards this direction. Now when they were heading towards these directions, what happens, guys, that Brooklyn's entered into the stands of H and they collided, okay, they collided over here, and whereby the Hall was injured a lot. Okay, so now let's see what does the court say. Okay, in this case, the plaintiff during a car race got injured due to the collision of two cars. During the collision, one car came into the stands which caused injury to the plaintiff. Plaintiff sued the defendant for the damages, but the defendant was not held liable. Now whenever there is a word held, it means it's a judgment by the court, guys. So but the defendant was not held liable. Why? Because it is you know, settled law, guys, that whenever you are, you know, attending these kinds of racings, there is an implied consent of this kind of risk. Okay, there is an implied consent, guys. This kind of risk is really very much okay, है ना. ये नॉर्मल सी बात है कि आपने जब कार रेसिंग में जाते हो तो ये ऐसे सब चीज़ें होने वाली है, करेक्ट. There was no intention, correct, it wasn't intentional. If there is no intention proved, how can you say that, you know, there's some wrong? This is a normal thing, correct. When you are participating in this kind of racing, then you know you consent, you consent for this kind of a harm. So later on you cannot claim compensation for the same, correct. So in this case, as the plaintiff himself took the risk of injury, so voluntary non-fit injury is really applicable. So the defendant used the defense of consent over here, so he was not held liable. Okay, next point is, guys, plaintiff is the wrongdoer. Now what does this mean? That plaintiff, as I told you, plaintiff is a person who files the suit, correct. Now defendant is saying whatever has happened, but the plaintiff himself was a wrongdoer. That is his defense in the courts of law. What is it? Ex turpe causa non oritur action. Okay, from an immoral cause no action arises. Okay, मतलब आप अगर खुद ही गलत हो, then you cannot go and say to the court कि मेरे साथ कुछ गलत हुआ है. Okay, for example, over here what they have taken is that, you know, A and B, okay, have decided to commit theft in C's house. Okay, now अगर यहाँ पे A and B दोनों मिलके थेफ्ट कमिट करने गए हैं और ए ने शायद कुछ, यू नो, उसके हाथ में कुछ, यू नो, से ही माइट हैव बी हैविंग अ नाइफ एंड ही माइट हैव इंजर्ड बी बैडली. Can B file a suit against A for, you know, negligence or, you know, for some injury or something? No. Why? Because whatever they were doing, the cause was immoral, है ना. The cause was unlawful, है ना. जो खुद शीशे के घर पे रहते दूसरे के घर पे पत्थर नहीं फेंक पाएंगे, करेक्ट. Whenever a person does an unlawful act, the person who suffers loss because of such an act has a right to claim remedy against him in the court, correct. It is one of the defenses which exempts the defendant from his liability because the defendant has also committed an illegal act. देखो, अगर आपका एक्ट ही अगर इलीगल है ना, तो आप कैसे भी ना उसको बचा नहीं पाओगे. जैसे कॉन्ट्रैक्ट लॉ में, गाइस, जैसे कॉन्ट्रैक्ट लॉ में आई हैव टोल्ड यू सो मेनी टाइम्स, इफ यू आर डीलिंग विद एन अनलॉफुल ऑब्जेक्ट, करेक्ट, इफ यू आर डीलिंग विद, आपका अगर सब्जेक्ट मैटर ही अनलॉफुल है, ओके, अगर फिर भी आपने उसको पैसे दे दिए, समझो फॉर यू हैव प्लेस्ड एन ऑर्डर ऑफ से 10 lakhs of cocaine, correct, and if a person does not, you know, deliver you the cocaine, can you go and, you know, claim in the court? No. Why? Because the act himself was immoral, correct, it is unlawful, the consideration is also unlawful, so you cannot take the help of the court. The same way, it is one of the defenses which exempts the defendant from his liability because the plaintiff has also committed an illegal act. Therefore this is also known as plaintiff a wrongdoer, correct. वो खुद ही एक wrongdoer है, correct. Illustration: A and B have decided to commit theft in C's house, but during this act A gets injured because of B's negligence. Okay, basically ये दोनों भी चोर है कि नहीं. Here, even though B is guilty of negligence, correct, there is some negligence from B's side. A cannot claim any damages because he suffered this injury as a result of being involved in an unlawful act of theft, and thus it falls in the category of ex turpe causa non oritur actio. Am I clear about it, guys? Whenever the plaintiff himself is a wrongdoer, this can be a very good defense for the defendant, है ना, कि वो खुद गलत था. How can he point at me? Okay, hope I'm clear about this. Let's move ahead. inevitable accidents, things which you cannot foresee, okay, even after a reasonable care, if you cannot foresee, then that is a very good defense. It is a very good defense. The inevitable accident, which is also known as unavoidable accident, says that a person cannot be held liable for an accident which was not foreseeable despite all care and caution taken from his side. Law states that a high degree of precaution is not required, reasonable care is sufficient. मतलब आपको मतलब see, if you are going on a road, okay, if you are driving on a road and you are going into this direction, and if you collide with a person somewhere over here, and because of seeing your bloodshed, if anybody who is on the opposite side, okay, and he is traveling this way, correct, which is not, you cannot see him, correct. So if anything happens to this person, seeing the blood of the the person who is collided with, then you cannot be held liable for his damage. Am I clear? Because you cannot see him, you are liable only up till this extent, guys, which you can foresee. Anything, because you don't need an extraordinary precaution, correct. Things that is reasonably foreseeable, you can be claimed only for that much, correct. Example, A was driving a car and he was all in his senses and took all due care, but suddenly, due to a mechanical part failure, his car loses his balance and hits a passerby. In this case, the driver would not be liable as he took all precautions from his side. The accident was unavoidable because it was what? Because due to the mechanical failure in the car, correct. So this can be a very good defense, okay, in the eyes of law. Act of God can be sometimes classed in inevitable accidents. For the defendant to use the defense of inevitable accident, it is necessary to show two things, guys. What are these two things? The intention. देखो, अगर आपका intention बुरा होगा ना, if you can prove the intention was bad, guys, then directly क्या आ जाएगा आपका criminal law act में आ जाएगा, correct, your Indian penal code. But if there is no bad intention, correct, if there is no bad intention, then only it will be a civil wrong, correct. So there was no intention on the part of the defendant, and what else, and the collision could not have avoided with reasonable care, है ना. अगर उसको पहले से, before he started his car and he was knowing that the brakes were failed, then there would be an altogether a different story. But all because it was sudden, guys, है ना. He proved that it was sudden. Once it is proved that it is sudden, then it will be a case of accident. It cannot be a planned thing, है ना, क्योंकि whatever the brake failure was sudden. So and the collision could not have been avoided with reasonable care. Am I clear about it? So it is not required to be a high degree of precaution. Only reasonable care is sufficient. This is very important point, guys, in when it comes to inevitable accident to use as a defense. Next is act of God. These are, naturally the heavy rainfalls, the earthquakes and all those things. There are two essentials of act of God. There must be working of natural forces. Occurrence must be extraordinary and not one which could have been guarded against, correct. If there is, say, ek bar in a 26th July, it rained so heavily, na, the entire Mumbai was floating. Or if there is a, say, an earthquake, correct. So this is something which you cannot, guys, it is not in humans' control. So this can, these things, can be, named as an act of God, correct. So if anything wrong happens during this course of time, then you can always have a defense of act of God, correct. Nicholas versus Marsland. In this case, defendant created an artificial lake on his land by damming some natural streams. Okay, उसने एक artificial lake create किया था. Due to extraordinary rainfall, see, the rainfall was extraordinary, it was not ordinary. Rush of water washed away plaintiff's bridge. Even it was said that the rainfall was heaviest at that time till that time, correct. तब तक की वो सबसे ज़्यादा बारिश थी. Okay, maybe something like 26 July, if you guys remember. Since it was an act of God and defendant could not guard that, he was not held liable because it was not within his purview, correct. Whatever the rainfall was so extreme, guys, that in ordinary course of man couldn't protect it. So how can he be held liable? Correct. So the court will not allow anybody to take advantages of such situations, correct. So act of God is always a very good defense, guys. Next is private defense. Reasonable force to protect one's person or property, imminent threat to the personal safety and property. One more point I would like to over here, that the blow should be proportionate. It has to be proportionate to the harm caused, correct. It has to be proportionate, guys. It can't be unproportional. For example, if you're walking down the street, okay, if you're going, say, for example, if you're going down for a morning walk, okay, and you're walking down the street and somebody comes and snatches, trying to snatch your chain, you make such a big chaos out of it, okay, then what happens, he couldn't snatch the chain, and he just goes off from there, he just runs away from there. The next day when you see that person in the market, you just take a hold of him and beat him up like anything, and you are just about to hurt him very very badly. So that can be private defense, guys. That cannot be private defense. Why? Was because there was not imminent danger to you, and even the blow was not proportionate, correct? So guys, wherever you can apply private defense, that is okay, that you need to protect yourself, your property, your near and dear ones. But then also there are certain limitations where you cannot take law into your hands, okay? So private defense हमेशा से उन लोग का favorite topic रहा है questions में entrance exam के. Please take care of 2-3 points which is very very important to justify whether the private defense should be allowed or not, correct? Creswell versus Surrey. In this case, defendant shot plaintiff's dog which was chasing his herd of sheep. Keeping in mind that the dog was actually attacking the herd when it was shot down by the defendant, and there was no other means to stop the dog at that time, the defendant was not held liable. Okay, he has shot the dog, correct? So maybe the dog was no more, correct? But why did he do that? To protect the sheep, herd of sheep. तो एक से ज़्यादा sheep होगी उसके पास, correct? So this can be justified. This defense can be justified. So here अगर डॉग का ओनर है वो, अगर इट मे बी अगर वो केस करेगा, जैसे क्रेसवेल इज अ डॉग्स ओनर, करेक्ट, उसने सीरी पे केस किया है, करेक्ट, देन सीरी कैन ऑलवेज यूज द डिफेंस ऑफ प्राइवेट डिफेंस. एम आई क्लियर अबाउट दिस? Moving ahead, guys, necessity, very very good point. It is always to avoid the larger harm, guys, to avoid the larger harm, to avoid the greater harm, है ना? A smaller harm can be excusable, a smaller harm can be allowed, correct? For example, देखो, अगर दो क्रूज जा रहे होंगे, उसमें thousands of passengers होंगे, they were supposed to collide, okay? The only way to avoid this collision might be to change the way, okay? तो अगर direction change करते हैं तो एक छोटी सी boat है, उसमें like 50 people होंगे, okay? So to collide with this 50 people would be a better choice than to collide two huge crews, correct? So what happened, they chose to do this. Then when the small boat owner filed a case, then the crews can always say that whatever has done, it is out of necessity to avoid the greater harm. So it is a very good defense, guys. Let's see what example I've taken here. If the act causing damage is done to prevent a greater harm, it is excusable. Very good defense is necessity. Case law, Lee versus Gladstone. Force feeding of a hunger striking prisoner to save her was held to be good defense to an action of battery. Now what happens if might be a prisoner, okay, who is in hunger strike, okay? So if anything happens to this prisoner in the jail, then the jailer will be held liable, correct? Because of this strike, hunger strike, he can even die. So to prevent this thing, what the jailer might have done, ask him to force feed, correct? So force feeding करते में क्या होगा, उसको हाथ पैर पकड़ के उसको, what is battery, guys? कि when somebody is touching you without your permission, which you are not liking it, है ना, forceful touching, correct? So what will it be? It can be battery. So force feeding of a hunger striking prisoner to save her was held to be a good defense for an action of battery. अगर यहाँ पे ये prisoner ने battery का केस कर दिया है, then you can say that it was necessity. What we have force feeded him because it was necessity to save him. So there cannot be the charges of battery. Am I clear about it? So it was to avoid the greater harm. A smaller harm is always excusable. So to avoid his death, the smaller harm of battery will always be excusable. Am I clear about it? So necessity itself is a very good point. Now let's see couple of questions, guys. You can when I'll read the principal facts and options, then you can pause the video and just check for yourself whether you can actually apply the explanation over here. Principle says a person has no legal remedy for an injury caused by an act to which he has consented. Okay, so what will be it? It is about nothing but about voluntary non-fit injuria, correct? A person has no legal remedy, correct? He cannot claim compensation for an injury caused by an act to which he has consented. Let's see the facts. R a cricket enthusiast, purchases a ticket to watch a T20 match organized by the Indian Premier League, that is your IPL, correct? During the match, a ball struck for 6 hits R on his body and injures him. He is to use IPL for compensation for the medical expenses. Now, which of the correct following derivations is correct? Correct. The options are R should be compensated as he purchased the ticket to get entertainment and not to get injured. Okay. B is R would fail in his action as he voluntarily exposed himself to the risk. C is IPL would be liable as it did not ensure that the spectators were protected from the risk of injuries, and D is none of the above. Guys, remember, always for your legal answers, anything that is a social language, anything that has an religious language will never be your answer. Will never be your answer. Correct. R would be liable as it did not ensure that the spectators, this is your social answer. This will never be my choice. Okay. And legal principles and facts में नोटा बहुत ही कम choice होता है guys. None of the above is also not a correct choice. R should be compensated as he purchased the tickets to get entertainment and not to get injured. Do you think this has any legal language in it, guys? Understand, it is a law entrance. We want an absolute legal language, guys. This is also not my answer. This is my correct answer. Why? R would fail in his action as the voluntary. When you're going for matches like IPL and all, when a ball hits to you over there, so when you're buying a ticket, you have already consented for this kind of a risk. Okay, it is an implied risk, guys. Once consented, later on you cannot claim compensation. So this is the correct answer choice, guys. Ignorance of law is no excuse. Okay, ignorance of law is no excuse. In this note, take a note of this, guys. Ignorance of facts is always an excuse. Okay, ignorance of facts, शायद कुछ facts के बारे में कुछ mistake of facts हो गया, is always an excuse. But ignorance of law is never an excuse. Correct. A fails to file his income tax return for 10 years. Imagine a person who is in a citizen of India and does not pay income tax for 10 years. The income tax department issues to him notice to show cause why proceedings should not be initiated against him for recovery of the income tax due from him with interest and penalty. Okay, now what is the principle saying? Ignorance of law is no excuse. Now to pay income tax is a law, correct? What are the options, guys? He may take the plea that his advocate has advised him not to file the return as his income was not taxable. Okay. He may request the department to waive the interest and penalty. A must pay the tax due as ignorance of law cannot be the ground of defense. None of the above, guys. Pause the video and you can check the answer. Now he may take that his advocate has advised him. Do you think that this kind of reasons, this kind of defense will the income tax authorities permit? Not at all. Correct. Why ignorance of law is not at all excusable, guys. He may request the department to waive the interest and penalty. Now this is what the partial answer, or I can say even social answer. So this is not at all a legal answer, guys. So this is also never my choice. Okay, none of the above also I said will very rarest of the rare will be none of the above your choice. Okay, A must pay the tax due to ignorance of law cannot be the ground of defense. Now you can clearly see, guys, that this option is a correct option and it also has a legal language. Your answer will always have the language of the principle. This is the thing you should note when you're appearing for your entrance exam, guys. Your answer, the correct answer, will always have the language of the principle. Correct. So C over here is a correct option. Okay, he has to pay the tax and even the penalty and the interest, guys. So guys, you can join for your law entrance whether you're applying for 22 or 23 batch, guys. We are we can offer you the online classes, we have the mock test, we have the entire thing that is required for the entrance exam, guys. You can join us on YouTube, we are there on the Facebook, follow us on Instagram, and guys, kindly join our Telegram channel also, guys. Here we post the quiz, we pose the questions regarding the vocab and very interesting things, and we keep you updated with the latest notifications from the from the entrance for the entrance exam, guys. And I have mentioned the link in the description for the Google form. Do fill up this form, and our team will get back to you as soon as possible. Okay, stay safe and prepare yourself to the best. Thank you.